very much agree with what Councilmember Catania has just said. We have places in Ward 6 where prostitution is a very, very serious problem. And I would appreciate having all the tools we could possibly have to put people on notice that this is not something that can continue to go on. So I will not be supporting Mrs. Patterson's amendment.
Mr. Chairman.
Mr. Chairman.
Councilmember Patterson.
Thank you, Mr. Chairman. I would just say there is a very pretty sharp distinction between carrying a gun, that is a behavior, and looking like a prostitute. I don't want to be trivial again, but that in fact can be a fashion statement these days. And I note that one of the categories, an F on page 12, would be observation by an officer that the person has no other apparent lawful reason for congregating in the prostitution-free zone, such as waiting for a bus or being near one's own residence. That is really overbroad. I don't want our current Metropolitan Police Department to have that kind of latitude. But that said, I can count the hours late. I withdraw the amendment. The next amendment, number 7, is also relates to the anti-prostitution elements, and this would strike the language after the phrase engaging in prostitution and essentially remove from the legislation making prostitution a crime. I'm sorry, let me be clear. What this would take out is the language addressed for the purpose of inviting, enticing, offering, persuading, or agreeing to engage in prostitution. And I think this, again, is overbroad language because it wouldn't actually require these things to happen, but it's an address for the purpose of. I think this is just overbroad, and I think it is not, it just wouldn't be good public policy, so I move the amendment.
I will ask members to vote against this amendment. This is a complicated area of the law, and it's also an area of the law that's been very vexing to residents who feel that prostitution remains a scourge in their neighborhood. The language that this amendment would strike was language that has been in the law and probably has been in the law since at least 1935. So it may sound like it's kind of vague or unclear or broad. In fact, it's been litigated, and I believe it is dealt with in Note 5 of the notes to the annotated code. So if we were to strike this language, we in fact would be taking a step backward in terms of what the prostitution laws are in the District of Columbia. For that reason, I would ask that members not accept this amendment.
Mr. Chairman, can I just ask how, if this has been in the law, how do you interpret this? It doesn't take away from the crime, the inviting, enticing, offering, persuading. How do you distinguish if someone is addressing? How do you know? I just don't understand how you define that.
I'm not a very good law professor, but it's been addressed by the courts in the different cases, and I think you'll find the discussion of it in the notes. If you, Councilmember Patterson, can between now and first reading point to me on how I'm missing something, I'll be happy to consider it. But I think what we tried to do and what we thought we were doing with this print is preserving language in the existing law.
I'll withdraw the amendment.